Hi, everyone. Thank you for joining us today. My name is Matt Kugizaki. I'm an attorney in Linn County's Legal Services, and I also help run our small business legal clinic here at ICLS. ICLS is a 501c3 nonprofit organization that provides free legal services to people in Riverside County and San Bernardino County. Our small business legal program helps provide free legal advice and guidance to nonprofits and to small business owners and entrepreneurs in the area. Thank you for joining today. This is part of our small business and nonprofit essentials. And the title of today's webinar is Responding to Subpoenas and Other Records Requests and Preparing for Depositions and Hearings under California Law. With which hopefully as nonprofit leaders and small business owners, you have not received a bunch of subpoenas, but it is something that you'll want to be aware of because as a nonprofit leader or small business owner or entrepreneur, you are working in the community, you're making agreements and contracts with other organizations and people. You may have customers, you may help people in a variety of issues. And as a result of all of these contacts and activities that you're doing, you may receive a subpoena. So we're happy that you're here and we're happy to provide information that will help you in the event you receive a subpoena for documents, a subpoena for testimony, a subpoena for a deposition, or other types of record requests. We will get started now. All right, so today we have two speakers. One on the right, that's me. As I mentioned, my name is Matt. I joined Linn County's Legal Services just this January. Before I joined ICLS, I worked as a corporate litigator for about 10 years. I represented companies and businesses in litigation, helped a lot of companies respond to document requests and subpoenas, and helped them through the process of making sure that they comply with those requests, while also balancing issues related to their organization, whether it be burden, if the document requests are asking for tons of documents, or other types of issues like confidentiality, if the requests that are being asked for are privileged because they contain communications with attorneys, private because maybe they contain notes between a physician or counselor and their patient, and other reasons why you may, other sensitivities about producing documents. I am with Ed Langhammer today. He is a member of Cozen O'Connor, and he has over 35 years experience representing clients in all types of employment law and related litigation, including wage and hour class actions, and suits involving wrongful termination, discrimination, harassment, retaliation, breach of contract, unfair business practices, and on and on and on. He is an expert in many things. As part of these lawsuits, he's developed expertise in helping businesses and nonprofits and individuals prepare for depositions and hearing testimony, and also helping them respond to document requests, to deposition requests, subpoenas, and all different types of requests relating to their business records and information from their employees. Mr. Langhammer represents corporate and business organizations as well as nonprofits and charitable entities. We're super happy at ICLS to have Ed here with us. And if you were here a couple months ago, he also spoke at a very, very helpful webinar about hiring and terminating employees. So those are the speakers today. And let's see. First off, I will get started with our legal disclaimer. Like any good lawyers doing a webinar, we are required to tell you this, but it's also really important for everyone to know that the information during this webinar is to help with spotting legal issues relevant to small businesses and nonprofits in the state of California. I think specifically it's to help give you information so that if you are to receive a subpoena or document request, you already have information, general information about the steps you may want to take immediately upon receiving those. One thing that you'll hear from us over and over again, if you receive a subpoena or even an informal document request of any time, it's best to start acting immediately. There are lots of deadlines which we'll be going throughout this presentation. that apply to these types of document requests. And if you don't respond within those deadlines, there could be pretty significant financial and other penalties and consequences. So anyway, this is a webinar that provides legal information that we hope will help you hit the ground running in case you get a subpoena for your organization later on. The presentation only discusses some of the important factors. In an hour, we can't talk about every single thing that you'll need to know about this topic, and is not intended to be a substitute for legal advice. At the end of the webinar, we'll talk with you about some options you may have if you are to receive a subpoena or if you want more tailored legal advice separate from this webinar. And the attorneys presenting today, Ed and I, are not providing legal advice or entering into any attorney-client relationship. We're here to provide info only, and nothing said during this webinar is confidential. And you should always decide what course of action is best for you, your business, and your nonprofit with the consultation of an attorney. So after that, let's get started on the substance of today. We've broken the webinar into 4 main topics. First, responding to document subpoenas. I'll cover that topic, and I will talk all about what is a document subpoena, when will you receive it, what you should do when you receive it, and ways to protect confidential information, other things to be on the lookout when you receive a document subpoena. Number 2, there are other types of document requests. A lot of people have probably heard of subpoenas, mainly because they're in the news all over the place. As a business owner or a nonprofit, you may have received a subpoena. It's a formal document request that is related to a court proceeding, but there are also all different types of other types of requests that are going to ask for your documents and your records. So we're going to cover that as well. Third, we're going to talk about responding to deposition subpoenas. So this is when someone is asking for your deposition testimony, and not only how to respond to that, but also how to prepare for your testimony. Fourth, we'll touch on preparing for hearings and other trial testimony. So it's similar to preparing for a deposition, but there are additional considerations at play. In the darkish blue, horizontal box, there's 2 notes that I wanted to highlight. First, this presentation is limited to California law. As California nonprofits and small businesses, it's probably likely that you'll be receiving subpoenas pursuant to California law. However, if you do business outside of the state, or if there's any other types of organizational contacts and activities outside, you may receive a federal subpoena. If that's the case, just know that while some of the rules and guidance will be similar, there are completely different laws, legal obligations, and timing considerations if you're receiving a federal subpoena. 2, this presentation is limited to subpoenas and requests when you're not a party to litigation. And one of the reasons why we wanted to do this webinar is when you're not a party, you may not have access to an attorney. So we wanted to provide information in this instance because it'll help you if you aren't, it could be all of a sudden if you're not part of a litigation that you receive this out of nowhere. So we wanted to provide you some of the information so that you know how to hit the ground running if you were to receive a subpoena. By contrast, if you are part of litigation, there are also formal rules governing the exchange of documents and deposition testimony. But if you're in litigation at that point, you should certainly have been talking to or are talking to a lawyer. So just know that the rules in litigation are different, but at that point, you should have a lawyer. And if you are in litigation receiving document requests, you should certainly see a lawyer immediately. Okay, so the first topic today is document subpoenas. Here are the basics. What is a document subpoena? A subpoena is a demand of sorts for specific categories of documents related to a lawsuit or an arbitration. And you'll receive a subpoena generally when you're not a party to that litigation. You may not even know that a lawsuit is going on and you receive a subpoena. They'll serve it to you personally or to your agent, personally to the agent of service for service of process that you have registered with the state of California. You'll get this subpoena and it may be the first time that you heard of a lawsuit. What it is a demand for the categories of documents, whether it be specific types of employment records related to an employee, maybe it's documents related to a contract or business transaction that you entered into a few years ago. Maybe it's documents related to a client or to a client or a patient that you're seeing, depending on the type of organization. Sometimes document subpoenas are in connection with a deposition, which means they're going to ask you to bring documents to a deposition or produce documents before and in connection with the deposition. And then they're going to want to ask you questions during the deposition about those documents. And sometimes, other times, you'll receive a document subpoena in connection with a hearing. So in a lawsuit, there's various hearings along the way. And sometimes they need a party or a person who's not part of the lawsuit to join or to attend that hearing and bring documents that are going to be evidence in that other case. One thing to be aware, though, even though you're not a party to this litigation, a subpoena signals to you that something related to your organization or your nonprofit, there is some sort of issue that is related to your organization nonprofit. So it should ring a lot of alarm bells. And it should make you think that this is very important and that you may want to speak with an attorney. Actually, in the second box, we say, do you have to respond? Generally, and I should have made generally very small because the answer is yes, you need to respond, you need to deal with this. There are circumstances where you may not need to respond. Maybe they serve the subpoena incorrectly. Maybe you have valid objections. Maybe they're only asking for documents that you are protected and don't need to produce. Then while you still need to respond and set forth those objections, just because you get a subpoena doesn't mean you have to produce everything they're asking for. You do have rights as an organization and nonprofit, and there are rules about what you do and do not need to respond. And that goes very well into the next bullet point, which is speak with a lawyer about your response. As early as you get the subpoena, I think that's really good advice because they're going to be the ones to help you determine what you need to include in the response, especially if you foresee any challenges. And I think one of the core challenges that people have who receive a subpoena is if they're being asked to produce or provide documents that are sensitive, like employee files. There's a lot of sensitivities with that. If someone is asking for your employees' records, you keep those private within your organization. You probably don't want to produce them just to anyone who asks for them. Or maybe they're related to a client or a patient. I know we have people here that provide counseling and other services to clients and other client-related services. You may have ethical obligations not to produce those documents to various people. You produce them to make sure that you do it in a way that protects against disclosure to anyone else other than the party that you're producing them to. If you have these challenges or you see these issues, it's best to talk with a lawyer when you see a subpoena so that you don't accidentally open up your organization or your business to more liability because you produce documents so wildly or just so broadly and freely. On the flip side, there are some subpoenas that are pretty straightforward. And while I still would recommend you talk with a lawyer about your obligations and make sure you produce on time or early and produce completely, maybe they're only asking for a small handful of documents. Maybe they need just the final version of a singular contract that you have in your files, and you don't care if someone else sees it. So there could be situations that are, that don't pose that many challenges and don't really require a lot of work. It runs the gamut. Either way, I think it's best to see a lawyer. So the next box that's gold says kind of a few bullet points of what should you do. When you receive a subpoena, review it very closely. Make sure that you do not speak freely about the subpoena to everyone in your organization, but you should talk to people if they're requesting documents that other people may hold. You should let them know about the subpoena and make sure, it says they're a document hold, make sure that people aren't destroying or deleting documents A very common question in subpoenas or request is for people's emails from a time period. If you're telling people that we received the subpoena for everyone's emails regarding a patient or a topic in the past 2 years, they cannot go and then just delete all their emails. That is wrong. It violates many laws, and there would be penalties if that were to be found out.
Yeah, hi everybody. I just jump in on one other thing. Social media. This applies as well to text messages. If you get and Matt will talk about this, but if you get a request for documents and it includes text messages, the answer is not to hit the delete key. That's not an effective answer, and you could wind up facing other consequences as a result of that. That's all I'm going to add. Thanks, Matt.
Yeah, no, I'm glad you added that. And one other thing that I know in my organization and a lot of companies that's becoming popular is having these internal messaging systems. We use Teams, chat, and all this. And subpoenas are increasingly adding not only text messages, but those internal chats in addition to emails and documents. And a lot of times the subpoena is going to be written very broadly, and it's going to say, we want all of your communications related to this issue, and that would naturally capture text messages and everything else. The next step that you would do is start collecting the documents, object if appropriate. On the next couple of slides, we'll go over some of the common types of objections that you can make. Then you will negotiate the scope of the subpoena. If they're asking for all documents in the past 20 years related to a very broad topic, that is obviously extremely burdensome and probably isn't tailored to the types of documents they actually need for the purpose of their litigation. So there's an opportunity for you to negotiate and try to find a narrower set of documents that they're requesting that works for your organization, but also gets them what they need. So you can negotiate the scope. You can also negotiate the deadline. If subpoenas often will ask you to produce documents within 15 days or a month or something that is pretty unreasonable, especially, you're running a business, you're running a nonprofit, you're very busy. You can negotiate the deadline. And usually attorneys who serve these subpoenas are pretty reasonable, especially if it appears and you're willing to help get them the documents they need. But they're pretty reasonable to extend the deadline. Or maybe they'll say, maybe it asks for 5 different categories of documents, and you can offer, we'll produce 2 categories by the deadline, but these other documents, it's going to take us longer because they're in storage or whatever. People are required in some way, I say required loosely, attorneys and parties have, duties to act reasonably, especially to third parties that are not part of a lawsuit. So you can negotiate some sort of flexibility in deadlines. One thing that is critical is you need to protect confidential information. Just because information is confidential doesn't mean you're not going to have to produce it in response to a subpoena or to a document request, but there are ways to protect it. We'll go into this a little more on a future slide, but there are agreements that you can enter into with the people you're providing the documents to. They're often called protective orders or confidentiality orders, or sometimes I've seen people enter into non-disclosure agreements. Depending on what they're requesting and the purpose for that, for what they need it for, you'll want to enter into some sort of agreement that restricts how they can use the documents and who can see the documents. Because without that type of agreement, if you're giving a bunch of, let's say, client files because they're asked for, because they're part of some issue unrelated to your organization, but you're giving them in response to a subpoena, if you don't have a protection, then they may file them publicly with the court. They may give them to, whoever their clients are. They may give them to the news, who knows? But if you have a non-disclosure agreement or a confidentiality order or some sort of other agreement, it'll say very clearly, the limits in which any documents you provide can be used, and whether or not sensitive information needs to be redacted before use, or whether or not it can be even provided to the court publicly. It may say in there that if they're going to file this with the court, they have to do it, in a redacted way or under seal is what it's called, to make sure that the information you're providing them is not just going to be then distributed to, the whole world. So it's very important. It'll come up later on, so I'll underscore it and talk a little bit more about how that looks. But I think protecting confidential info is super important. One theme with subpoenas is you're not part of this lawsuit, but you don't want to, because of how you respond or fail to respond, create a separate lawsuit or legal issue that now you have to deal with because you either didn't respond and now someone's going to file, a lawsuit or a motion against you, ordering you to respond, which may have monetary sanctions involved if you don't respond, or if you respond, in a sloppy manner or aren't taking care about protecting confidential information of your clients, they may now have a lawsuit against you because you responded so broadly. The last bullet point is just failure to comply may have severe consequences. Totally true. There are financial penalties that could result if you don't comply. You could also get yourself an additional legal issue. If people don't, I've seen situations where people get a subpoena and parties don't comply, and then they just try to bring you into the lawsuit because maybe you're on the fence of whether or not your involvement should be part of this civil lawsuit. But if you're not cooperating, they'll bring you in and find a cause of action maybe against you. So you want to comply, of course, reasonably in protecting your interests and your clients and customers and other interests. All right. So the next slide goes into some of the specifics. What is the deadline to respond to a subpoena? So as I mentioned before, the first thing if you get a subpoena, and they're usually not very long documents, and they are form documents that you can download off a court's website, but they will tell you when the party who has given you the subpoena has asked you to produce the documents. So the deadline is on the face of the subpoena. I should have put an asterisk there because just because they give you a deadline doesn't mean that that deadline is legal. If the deadline is, only a few days away, then that subpoena could be deemed invalid. So you may not have to respond. But generally, they can put a deadline that's 15 days after service. In California, that's usually seen as reasonable. So that would be when you have to comply. If applicable, there is also a notice to consumer, which we'll talk about on the next slide. There are deadlines associated with that. So what is a notice to consumer? So for certain records, and let's say employment records is a good example. Let's say a party is trying to subpoena the employment records of a former employee. Let's say that former employee is part of a divorce, and in their divorce action, they need your employment records because they need to determine how much money they made. That's a dispute in their divorce action. You're not going to be part of that other action, but you've been brought in part because you are the owner of certain records. Because an employee is considered a consumer, and there are other people who are also considered a consumer under California law, which would include, employees, patients, and other people. So if there's someone else's records that you're producing, then what is proper is, or what is required is for the person asking for those records to send a notice to that consumer or to that employee to give them a heads up that they're looking for these records from their former employer, like you, and it gives them an opportunity to object to the subpoena. Maybe they, are saying, look, they have rights to object also. Maybe they're like, hey, no one should have a right to see my employee records from 10 years ago. Maybe the subpoena is trying to get too many records, or maybe the subpoena is asking for really invasive documents about their employment, maybe disciplinary records. I worked on a subpoena once where it involved medical professionals, and there are specific privileges that apply in disciplinary proceedings or questions involving physicians and other medical professionals. So that employee whose records were being sought had a right to make certain objections. So if you are ever receiving a subpoena and it deals with records involving an individual, what should go up in your mind is, wow, did that individual get a heads up? And if they didn't, that's something that you'll want to talk to an attorney. Before on the slides, when there was a question about, are there any challenges or questions or issues related to the subpoena, that would be one of them where you'd want to talk to an attorney to confirm that the person asking for your records went through the proper processes. Because if not, and you produce documents and they didn't go through those processes, that employee now can be mad at the person who requested their documents, but also at you for producing them. And they may try to go after you for damages caused by not properly letting them assert their rights related to a subpoena. Again, and that will shift the deadlines. And as I mentioned before, you can get extensions to deadlines, but they're not guaranteed. So whatever is listed on the front of the subpoena, you should assume that is the deadline for you to produce all of the documents requested, unless you get an extension from the attorney or the person who sent you the subpoena and get that extension in writing. So what's next? You can object to the subpoenas, and you generally will serve or provide or respond with written objections. So you get a subpoena, you review it, and you're like, wow, I don't really know what they're asking for. These requests are confusing. They're asking for way too much information. They're asking for really invasive information, and I cannot see how this would at all help them in their lawsuit. And we see this a lot. A lot of times people want to get very invasive documents, especially medical, psychological, health records, mental health records, because they want to use them improperly in their lawsuit to try to embarrass, whoever's records those are. If things are like them, they seem to be harassing, you can object on that basis. You can object if it's going to be overly burdensome. Let's say they're asking for 10 years of records, and that's just unreasonable for you to go back and try to find these records in an archive. You can object on that, on that ground as well. Other objections relate to if the information is sensitive or confidential, or if it's privileged, if they're asking for communications that are protected between a doctor-client privilege or psychotherapist-client privilege, attorney-client privilege, you can object on those grounds. There's other objections that are related to the defect of the subpoena. If they mail you a subpoena, you may be able to object because that's not proper service of the subpoena. If they try to fax you the subpoena, that's generally not considered proper service. So you can object on those grounds. If they don't tell you where to produce the documents, when to produce the documents, or if they're asking you to produce them in 3 days. I once got a subpoena for a client that literally asked for us to produce the documents in 1 day. We objected. I mean, that's not valid under California law. One takeaway from this slide is that you have rights if you receive a subpoena. You don't have to necessarily always give whoever's asking you for documents everything they're asking for. It may be too much, it may be unrelated, it may be harassing. And in fact, you may not want to give them everything they're asking for because maybe it will, involve other privacy concerns relating to your client, right? Or to your customers or to your patients. But the other takeaway, I think, is it is very complex legal questions. It involves very complex legal questions about what you can produce and what you cannot produce. So another reason, if you do receive a subpoena, you'll probably want to talk to a lawyer about that individual subpoena or requests. The next portion of the slide, and I'll talk very briefly about this, is you can also file what's called a motion to quash or motion for protective order. These are fancy terms to ask the court for protection. Let's just say someone keeps serving you a subpoena and you've complied, or maybe you gave them documents in response to a subpoena and they keep doing it over and over again. And you're like, enough is enough. This is a huge disruption to my nonprofit. This is a huge disruption to my business. What can I do? You can talk with a lawyer and they can help you prepare a written motion that you would file with the court and ask the court for some sort of, protection. And with these motions, the other side has an opportunity to respond. There's a hearing. Please know there are strict deadlines of when you need to file these motions and when all of the other documents must be filed. And the loser of these motions could face monetary consequences and other types of consequences. So if you have a really strong argument, that's great, because if they're harassing you and the judge finds that they were harassing you and it was not they weren't substantially justified in sending these subpoenas, they may get an order to pay you in response to that. But if you also make arguments that aren't valid and you lose this motion and they're like, look, you got to produce these documents anyway, you may be on the hook for additional consequences. So you should really talk with a lawyer if it's something that you want to fight. All right. So here, these 3 points, we've kind of touched on all of them. Obviously, if you're getting a subpoena for documents, you need to know where to send the documents. On the subpoena, it'll also tell you where to send them. You can also talk with the person who sent it about finding another way. Oftentimes, it's going to be like a random office somewhere within your county or where you live, but you could agree to send them electronically or some other way if that works for the other side. And you'll often want to include a custodian of records declaration, where they'll probably ask you, if you're producing documents, to include this declaration, which just helps. Well, you will declare that these are, business records, true and correct copies. There's kind of some magic language that they'll need in order to use the records in court. A confidentiality order, we talked about this quite at length. I think it deserves its own box on a slide because it's super important. If anyone is asking for sensitive records, and it doesn't have to be even sensitive records about a client or a customer. These could be records that include your trade secrets or customer lists, or how information about your product that you don't want out in the public. Please ask them, or maybe demand is a little strong word, but have them consider, or you should consider making them enter into a non-disclosure agreement or confidentiality order before you produce documents. Most of the time, people will agree to this because they want the documents only for purposes of litigation, and you can work out a way to protect whatever interests you have while also getting them the documents you want. But what you don't want to do is just produce documents without any sort of protection. Just because it's part of a lawsuit and the attorney seems super nice and says, oh no, we'll just use them for the lawsuit. If it's not in writing, then it may, they can change their mind, and often they will. And then the last thing is, which we talked about, the notice to consumer is super important to consider if the records that are being, that you're getting requested relate to any sort of consumer records, including employment records, health records, I think bank records. There's a whole list of them that would count. So if anyone else is involved, and think of it this way, if the records, let's just put you in the shoes of the person whose records are sought. If you think that you would want a right to at least consider whether these should be given to random people, then it very, very well may be a notice to consumer issue to consider. All right. Oh, there's another slide on this. Just know that if you receive a subpoena, you could be entitled to copying fees. So if you do have hard costs, keep an itemized list of those costs, and you may be entitled to recover some of those fees. We talked about motion practice. This is if you want to fight the subpoena. If you don't want to produce what they're asking you, you can get an attorney, or you could do it on your own, but I highly recommend getting an attorney because they're highly legal arguments and there are consequences if you lose this motion. You can ask the court to protect you. The other side can also ask the court for an order to force you to produce. It's good to know that a subpoena is, in a lot of ways, a court order ordering you to produce. So you don't want to just wait until you get another court order. There are consequences if you just don't comply with the subpoena. And the last bullet, or the last note here, is put everything in writing: your objections, your responses, confidentiality orders, any agreements, any extensions to deadlines, any narrowing. Maybe they're like, we don't really need these documents. Get that in writing. Put it in writing, or else it really didn't happen, or at least will be very difficult to prove. All right, so we're done with the first topic, which is subpoenas, and we're going to move on to the second topic, and Ed's going to take over. I'll do a bit of a preview on the slide. So in addition to these formal subpoenas, there are also a few different types of other document requests. One are pre-litigation requests for records, and we're going to go into depth, or Ed will, in the next few slides. The second are kind of informal document sharing. You'll see sometimes people will just ask you for documents. This could be helpful. You'd probably want to talk to an attorney about this. Either way, all of the same protecting confidential information of customers or clients whose records they involve in or of your own business would be important to consider. Sometimes these are helpful to avoid a formal subpoena. Someone may reach out to you and say, you know, we're thinking of subpoenaing you, but if you just give us this one document by Friday, you know, we won't subpoena you. And if something like that were to happen, just get that agreement in writing. Because the last thing you want is to be super accommodating and then they subpoena you anyway. And then you go and say like, well, we had this agreement. And everyone's like, well, where is that agreement, right? So that could happen. And then finally, FOIA or Freedom of Information Act and Public Records Act requests. These are on public entities, so may not apply to the businesses or the organizations here. But just know if you were to receive one of these requests, they follow very different rules and you should speak to an attorney. Or they're often a tool for organizations and businesses if you want to get records from public entities. And sometimes that is very helpful. Our organization, for example, sometimes we want to know what the counties are doing with regard to a specific program. So we send Public Records Act requests to understand how they're administering, you know, various programs that are related to the client work that we do. With all that, I'm going to hand it off to Ed now to talk about pre-litigation demands and everything else.
Thanks, Matt. Hi, everybody. Thanks for hanging in there with us. First off, let me set the table. When we're talking about these pre-litigation records requests, I'm an employment lawyer. That's all I do is defend companies who are being sued or being threatened to be sued by their employees or their former employees, typically. So the table that I'm setting is with respect to this. Unlike a subpoena that we've been talking about, that Matt's been talking about, this is a document that you may wind up getting in your office, which is pre-litigation. And that means there's not going to be a subpoena attached to it. The way you generally will get it is that if there's a letter from a lawyer, the lawyer will say, hi, I represent, you know, Joe Smith, your former employee, and we're making a request under some of these labor code sections that we're going to talk about for copies of his records or her records, and attached is a copy of their release for the information. So that's a very different tool. And the thing that I will point out to you from the get-go is don't ignore that. That is a incredibly important document from the standpoint of you are now on notice that an employee, or more likely a former employee of yours, has reached out to an attorney and said, I think I've been mistreated at work. And this is an opportunity for the lawyer to get a hold of documents from you, which they believe may be helpful to considering whether they should file a claim against you, against your company. And if that happens, don't ignore it. The other thing is if you fail to do it, there's a $750 penalty that attaches to it. And if you dig deep enough into these laws we're going to talk about, there's actually probably a misdemeanor exposure, although I've never ever seen it charged as a crime. If you ignore it, it gives the lawyer who's representing that employee cause to believe that you've got something to hide, and that you're just sloppy. And that becomes another opportunity for the lawyer to say, well, you know what, I'm just going to file a lawsuit then. But this tool only works if there's no lawsuit. If you've already been served with a lawsuit, then what Matt has said about subpoenas is going to apply. So really, what are we talking about? These records requests are going to usually ask for a couple of different buckets of information. And one is with respect to itemized wage statement. And that is typically, when we say wage statement, we're really talking about a check stub. That's a wage statement is a fancy name for a check stub. So if you have employees You should be paying them by a paycheck, could be direct deposit. That's another piece of it. But they should all have wage statements. They should have check stubs showing the amount of money they earned, how many hours they worked, if they got any overtime, if they have sick pay. That wage statement should have their net wages, any taxes that are withheld, any contributions towards benefits that they may have to pay, employee contributions. So all of that information should be in these wage statements. And if you're asked to produce those records, then under this Labor Code section 226, the short answer is generally, if the records request is valid and it's an employee signed, employee provides a release, you're generally going to have to produce those records. And again, I've already talked about it. It's got to show wages, information on who you are, your address, total hours worked, dates of the pay period. We can go through it, identifying information, your name and address. Failure to have this kind of stuff is actually a technical violation under the law. And then you can be subject to a variety of penalties for non-compliant wage statements. The takeaway here is that I know there's a lot of small companies and you may generate your own payroll. That's terrific. You can do that if you're able to. Using a third-party vendor who can help you to do this is sometimes a good way to go, because they will likely assist you in being compliant with all of these little details and nooks and crannies that you may not know about. If you're still writing hand checks to your employees, then you still need to give them something that looks like a wage statement that shows all their hourly rates, all the other information, so they can figure out, A, how much am I getting paid? What are the deductions? What are my net wages? And actually, you need to have even sick leave on there. Under California law, all companies, even small companies, are required to give their employees 3 days, or they're full-time, or prorated if they're part-time, paid sick days under the law. So you need to be mindful of that. Now, how do you comply? Well, we already talked, that's the right side. If you have computerized printouts, if you have wage statements, you have payroll reports, that's one way you can provide the information. One of the key things is if you get payroll reports which has other employees' information listed, which is very typical. You get a payroll run that'll have, if you have 5 employees, all 5 of them be on there. You need to make sure you only produce the one that applies to this particular request. So that involves just blocking out the information, redacting the information. Again, if there's something missing, you could wind up with issues. The other thing on this piece of it is there are also wage statement penalties. These itemized wage statements, you can be liable for $50 for the initial period, $100 for each subsequent period, up to a max of $4,000. So that's a lot of money for most companies. And if you're in a position where you have multiple employees and for some reason you're involved in a claim involving multiple employees, for example, I do class action work and I do represent companies who are being sued under what we call PAGA, the Private Attorney General Act. This just is low-hanging fruit for lawyers who represent employees, so you need to be mindful for that. And then what's the timeline for complying? Some of these letters will actually say you're required to produce these documents within 30 days. Some will say you're required to produce this part within 21 days and this part within 30 days. For wage statements, the technical requirement is you have to respond within 21 days of the request. And the law says as soon as practicable, which is a little bit fuzzy language, but for wage statements, it's generally 21 days. I think we can go to the next slide, Matt. Employment instruments, contracts. So what do you need to produce? Now I'm talking a little bit more. I'm not talking about wage statements per se. I'm talking about the other bucket these records tend to fall into, which are your personnel records. Personnel records are something that you should always keep as confidential documents. They may have sensitive information with respect to your employees. So you want to be mindful of keeping those documents confidential. But when your former employee asks for your personnel records, then you have to be mindful of what you really have to comply with and what you don't have to comply with. And if it's anything the employee has signed, generally you're going to have to produce that. And that would include things like discipline, if you give people written warnings. Those all would have to be produced. Under the Labor Code 1198.2, they're entitled to receive a copy of their personal records that you maintain according to your regular, policies and practices. There's no hard and fast definition on what's a personnel record. So it's really up to the company to determine if you need what you're going to call a personnel record. One point I see is there's a whole lot of stuff in people's personnel files that really don't need to be there. They're not really related to personnel type issues. And sometimes you just throw everything into a file. Either it's a virtual file or it's a, it's a paper file. So you need to be careful with respect to that. And for personnel records, the requirement to respond is within 30 days. And then there's also requirements, which is beyond certain documents in your files. You need to have at least some sort of a minimum records retention requirement, because you do need to keep these records even for your former employees that you may need to provide if you're requested either the pre-litigation records request, or if it's in litigation, you may be there's other tools. A subpoena is one of them, but you may be asked to produce those documents. And those include, payroll authorization forms for any deductions, notices, commendations, warnings, discipline, termination notices should be the hiring and as we talked about in the last time we did a webinar, document. When you hire somebody, it should be documented. They should understand the terms and conditions of their employment, how much they're going to be paid and so forth. And when you terminate an employee, it's even more important that you make sure you keep copies of whatever the termination documents are. That may include discipline, that may include warning notices, their final paycheck. You're required to give them certain notices, pamphlets, and other information. If you have medical insurance coverage, there may be a COBRA issue or California COBRA issue if you're small. So it's generally a lot of information. Let's go to the next slide because there's some things you don't actually have to provide. So if there's a situation, you're in that unfortunate situation where there may be, investigation of a possible criminal offense, you don't have to produce those. Those would be something that would not be part of ordinarily of a pre-litigation request for records. Letters of reference, generally you don't have to provide. If you have documents, and some of you do, of information that were obtained prior to the time of your employee's employment, prepared by committee members, whatever that might be, and obtained in connection with a promotional exam, you may not have to produce those records. If you're in an agency where these where there may be police or fire who are protected under the Peace Officer Bill of Rights, which includes firefighters, then that's a different issue. They may not have to be produced. There's a special process for that that we're not going to get into, that people need to jump through those hoops. So if you're a government agency, you're connected to a government agency, and you have peace officers who are, again, police, fire, then you need to be mindful of that. And then there's other exemptions. But the key takeaways: review your wage statements, try to make sure they're as compliant as you can. Make sure the information route. If you have non-compliant wage statements, then that just becomes an opportunity for from a lawyer representing that employee to have a technical violation. You got to have you got to have information on their hours work, paid sick leave that's available. You have to keep your personnel files, for a minimum, of several years, 3 to 5 years, not unusual. Claims could come up. You may get a request from somebody long after the fact, long after they're no longer even your employee. So you need to be mindful of that. Again, Matt said it, a number of times. If you're really concerned about it, talk to a lawyer, understand those deadlines, understand what does and doesn't get produced, figure out what the rules are to the extent you're confused about them. And again, there are penalties that could apply for not timely complying with these records. And also, if you got good records and you really have sort of nothing to hide, that's really in air quotes. Sometimes if everything's tight, the lawyer will say, yeah, there's really not much there. Employees will go to a lawyer, and the lawyer is going to not necessarily look at the issue the employee is there for. The lawyer wants to look more at things like wage and hour issues. They want to look at how you've been paid. And that becomes, because those lawsuits are just awfully prevalent right now, and sort of the bane of our existence. And used to be big companies were targeted, medium-sized companies are targeted. Now more and more we're finding that small companies are getting targeted. So we could go to the next slide. Deposition subpoena, this again, there's litigation already filed. I mean, just real quick. And this is generally, I'm going to use the example, you're going to get a deposition subpoena with respect to something, and you're not involved in the litigation. That means you're not a party to the litigation. So you're getting basically a third-party subpoena. Well, why would you get it? They think you're a witness to something. They think you have documents related to something that they are suing about. So if that comes in, there's a lot of things you need to think about, you need to do. One is, on the caption of the subpoena will say who the parties are. And if you don't recognize the parties at all, that's one, that's information for you. But if you recognize the party, you may already have some understanding of why are you being called in as a recipient witness? What information do they think I have? Deposition is a formal procedure. It's under oath. You show up in a lawyer's office. Well, in the old days, now we do these on Zoom. But even though it's a private proceeding, it's in a lawyer's office, you're going to be put under oath by a court reporter. Testimony is going to be transcribed. There's going to be a lot of times a video kept of the recording. And you're going to be under oath as though you were testifying in front of a judge and a jury in a courtroom. So you need to be very concerned. This is it's a serious procedure. And you need to make sure that you're prepared for your testimony, that you have sufficient information. And the other ones that come up for businesses and business owners, even small business owners, is sometimes it's directed to a person. Joe Smith, president of the company. That's one example. But the other one is, the person most qualified, and then it'll have a list of different topics that you have to comply with. And so in order to determine person most qualified, it's actually could be more than one person, because it's not unusual for somebody to ask 10 questions and say, well, I know I'm qualified for 5 of them. The other 5 I'm not qualified for. So who in my organization may be qualified? So you're part of your job, and this is all subject to a lot more discussion, but the short takeaway is, if that happens and it's a person most qualified or person most knowledgeable, then you need to stop and think and really determine what you need to do to respond. Do I have to respond? Yeah, generally, again, as Matt said, generally, yes. Yeah, you want to talk to a lawyer if you possibly can. If you think there's going to be any issues, if you recognize the names of the parties, you think there may be something going on. It could be as simple of you get a deposition subpoena in your private life, and it's because you were a witness to a traffic accident, and someone wants to know that if you're a recipient witness to that traffic accident, they want to get your testimony. Is it a green light or is it a red light? So sometimes that'll happen because that's the way to compel testimony. On the other hand, if you're privy to information with respect to one of the parties to the litigation, which can happen, it's a business colleague, it's an associate, it's someone that you know, and you get one of these deposition subpoenas, then they're going to ask you questions with respect to your actual knowledge of events. That's who, what, when, where, why. It's, if you ever do get put into a position of testifying, you just want to make sure you don't stray, answer the question, think long and hard before you answer it. If you don't understand the question, ask for clarification. Don't stray beyond the questions. Don't guess, don't speculate, don't assume, don't give more information than you need to. There's lots and lots of practical things you do when you're actually going to have to give a deposition subpoena, including practicing. If you can talk to a lawyer and have practice sessions so you can anticipate questions and answers, and don't blow it off. I mean, if you just ignore it, it's sanctions. I mean, if it's if it's a pre-deposition subpoena, they can get a court order to compel you, can ask for sanctions. So you don't want to just ignore it. Patrick, Matt, do we have another slide? I think we do have another couple of them, right? Okay, so we've really talked about most of this. It's a formal request for your appearance. Do we already do this one?
I think there was a lag. This is the next one.
Ah, okay. Sorry. Yeah. So basically you need to know the date, time, and the place. If the date's a problem, the time's a problem, the place is a problem, you can always, you or your representative can reach out, ask for additional time. Yeah, virtual in person, we talked about that. Is a person most qualified, same as a person most knowledgeable? Are you required to be in person? Do you have to produce documents? But subpoenas are also often attached with a request for documents. So again, it's everything that Matt's already talked about before. You can get witness fees if you have to go. You get mileage, you get a certain amount of money. It's $35, I think, for a day. And so you certainly have the right to object if you think it's beyond the scope of, you don't know anything about it. I mean, but again, all of those are complicated issues that you need to, you need to think about. Do you need help in identifying those issues? And again, you could object. There's lots of bases to object. If it's irrelevant, it's objectionable, they're asking for personal information to such an extent. You have a right to privacy just because you get a subpoena. That doesn't mean you give up your right to privacy. So depending on what they're asking, something may or may not be legit. Review the subpoena, keep it confidential as much as you can. Prepare and object. We already talked about that in a different context. If the time doesn't work for you, the date doesn't work for you, you feel free to reach out and negotiate those items. Most people who are issuing subpoenas really want you to cooperate and get your testimony. The other thing to say, because I haven't said it out loud, is if you do get a subpoena, you may get it from one party or the other. You may get it from, Attorney Joe Blow. Well, you may show up for a deposition and there's more than one lawyer there. And those other lawyers, even though they didn't subpoena you, may also have the chance to ask questions. So you want to be mindful of that. Do we have another slide, or we
do.
Okay, so the rule is be on time. Don't come in rushed. Don't come in last minute. Make sure you know where you need to go, how long it's going to take you to get there, where you're going to park. You want to be well rested. The first question I always ask in a deposition, well, after state your name and address for the record, the first question I always say, are you under the influence of any, alcohol or drugs that would impair your ability to give your best testimony? And if someone says, yes, then I have to inquire a little bit further. If I say, without violating your rights to privacy, what can you tell me about it? Well, I had 3 bourbons this morning on the drive to your office. That's a problem. I'm taking a prescription medicine. So you have to be, if that is you, and hopefully the alcohol part's not you, but if there's some medication that you're taking, you need to be mindful of that. Bring in an attorney, I have mixed feelings about that. I mean, what do you have to hide? Bring a lawyer, it's going to be a tip-off. Sometimes we work behind the scenes just to make sure you're prepared. We understand what the scope of your testimony is. Depositions can't go on forever, so there have to be limitations on it. And again, I already talked about the other stuff. If you're going to answer a question, listen, take your time, pause. You may have a lawyer there may be another lawyer there who wants to object that the question is not properly asked or make some other objection. So you need to just take a deep breath and pause and go slow and answer only the questions that you're asked. Don't stray, don't make stuff up. Fancy name, don't speculate. If you don't know the answer, say, I don't know. But depositions, if you're being asked to testify, if the answer is yes, say yes and stop. If the answer is no, say no and stop. And if the answer says why, and you're being asked to talk about why, and you don't know why, then the answer is, I don't know. That's a perfectly fine answer. Other tips, take breaks as you need it. You're not in a locked door. You're not barricaded until you're able to respond. If you need a break, take a break. Sometimes if you have a lawyer with you, the lawyer's going to say, let's take a break. Court reporter gets tired. The other folks get tired, taking a break. There's no shame in saying, I need to take a break. You'll be asked to review your testimony. You'll get a transcript at the end of it. And if you need to make edits, you can. The problem is if you make edits, it can be used against you subsequently. If you're asked, was the light red or was the light green? And you answer the deposition and you say, the light was red. Then you read your transcript and you go, well, no, that's not right. The light was green. You've just created an issue with respect to your own credibility. So that's why we say, don't guess, don't make stuff up, don't speculate, and try to give your best testimony. It's the best opportunity. Practice, prepare, read notes, look at yourself in the mirror, have mock questions asked. And again, the impeachment is just a fancy word of saying that a judge thinks you didn't tell the truth about stuff. And we see that all the time. It's in news now. Everybody, news cycle is covering lots of court trials, lots of proceedings. We've got the January 6th hearings going on. So you can see in real time how witnesses are being challenged on their stories. And I think, do I have to testify again? Yeah, maybe. If there's a trial, you may be called into court to testify again. If you give a deposition subpoena, you could be called to trial on a trial subpoena, which again is, then you have to show up. You're maybe entitled to another witness fee. They'll tell you the date, time, place you're supposed to appear. It can be frightening if you get a subpoena to appear in court or a grand jury proceeding or a criminal proceeding. Other administrative agencies can issue subpoenas. The labor board can issue a subpoena. If you're in arbitration, they can issue. So you can get subpoenas from other places besides just courts. And even if you gave testimony or voluntary statements, you can still be subpoenaed to appear and give your story again under oath. So everything we talked about applied. There'll be a judge or jury. They determine, the judge determines procedural rules, the ground rules. The jury is the one, if there's a jury, ultimately determines whether they believe you, how credible you are. Things you do in court as far as how you show up, how you dress, your appearance, your mannerisms. You seem to be evasive? Are you being truthful? Are you looking? There's lots of different things you can talk about, and we're running out of time. And if you can't remember something that you remembered before, then whatever prior testimony or depo transcript or whatever can be used to refresh your recollection. To use my old example, if you said the light was red, then you change it to green, then you testify at trial, the light was back to being, red, that's going to be a problem for you. So again, if there's confidentiality issues, what Matt's already talked about, listen, pause, respond. Sometimes the judge will object and say, hey, lawyer, move on. That's not a fair question. And then be mindful of just how you come off. Practice. It can be a daunting experience if you ever have to go into court and testify as a witness during a jury trial. And yeah, so what do you do if you receive any of this stuff? Let your organization know, speak with an attorney, remember, calculate whatever your deadlines are, review what the documents you've been given so that you understand what's being asked for. If you need to object, negotiate, you need to do those things. We've already talked about that. Prepare for your response, practice. Make sure you know what you need to know. If there's confidential privilege information, that's another consideration. If those of you are in businesses where you have to protect a certain amount of confidential, proprietary, trade secret, patented, whatever it may be, you need to make sure you do what you can to protect your information. Just because you got a subpoena, it doesn't mean you have to give them everything if you have a legitimate business reason, but the devil's in the details. Again, and Patrick, I think options, ICLS, and you can talk about that a little bit more. Lawyers are available through lawyer referral service. If you have a friend, you have a colleague, you have an acquaintance, if you're in a business where you have a board of directors, it should immediately be turned over to your board of directors. If you're being called as a witness to produce something, to testify with respect to your business organization, make sure you're talking to whoever it is that either your board, your president, your CEO, your CFO, whoever it is in charge. And with that, I think we're out of time.
Yeah, we are. Thank you so much, Ed. One thing I will say, ICLS, we do run a small business and legal clinic that provides businesses and nonprofits of advice. So if you do receive a subpoena, you can reach out to us. We may be able to help go over it or connect you with an attorney, or at least provide information about a lawyer referral service. And the way to do that is to reach out to me or apply using the website there. If anyone has any questions, I know that we are over on time, but please feel free to reach out to me if you have any questions or you want to know more about our services and how we might be able to assist your organization. All right. Well, thank you, everyone. Appreciate your time. I'll be sending an email out to everyone who attended, so you have my email address in case you have other questions, along with the recording if you want to reference anything later. All right. Well, thanks and have a great day, everyone.
Thanks, everybody. Stay safe.